I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what today is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what today is.
All right, it is that time. Good morning, everybody. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're gonna go ahead and get into it. Hopefully y'all are doing well on this Tuesday morning. Oh my gosh, I can't believe it. Is it already Tuesday? I know. We had a long day yesterday, and I know some of y'all were still locked into the trial as well. Wow. A lot to talk about. All right, I see the ones in the chat. Hopefully we're looking good this morning. Ooh-wee. Looking all crispy and clean on the screen. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats of ClassEbeats.com. Today we are getting back into the YSL trial. I'm not going to do the long intro because y'all know we had a lot that we missed yesterday afternoon. Doug Weinstein got up there, was cooking. Max Shart, he got to finish his closing statements as well. So we're going to go ahead and get into it. But before I do, you know, I got to show love to the people. Shout out to everybody who's in here. My awesome, amazing Amy is in the building, always in here. First thing, showing love and support. I appreciate you, Amy. Thank you so much. We got Jermaine in here. Shout out to Jermaine. We got Stuck Farmer, Investigator Burrito. It looks more official than Viverito. Leona's in here. Hilton loves Fanny. These things are crazy. Daryl, Michi, Walter, my guy, Shane, Leona, Babs, Aphids, Valencia. We've got Nana Banana dropping the 2-bomb early this morning. Thank you so much for the support. And I will be reading super chats throughout the show. So thank y'all for sending the super chats. Fatima's in here. My dog, J Buckmaster, along with Rice Street. Like number 127. Thank you, thank you, thank you. Who else we have? Sue is in here. Asia's in the building. Always good to see you. Gerald, Gigi, good morning. Lavisa's back in here. BG Nino. I know I'm missing a bunch of y'all. Angela, Joanne. Who else? Who else? Who else? Oh man, Anthony Thomas. Good to see y'all. I'll be saying good morning to a few of you. Under Oath is in here too as we go throughout the show. So today we are getting into jury instructions before they start deliberations. And y'all know I've got to get the poll in the chat. So I'm going to ask you all in a second how long you think it's going to take for the jury to deliberate. Wasn't expecting them to start today, honestly. I thought it was going to maybe be Wednesday, but Judge Whitaker had a long day. I know Cat Not Williams was streaming for 12 hours. I said, hey, that's some commitment. I'd be out here working, but Cat was insane. So y'all give it up to Cat Not Williams for, oh my God, being committed. Either way, I'm going to go ahead and drop the poll in here and see what y'all think about deliberations. And we'll go ahead and get right into trial coverage because Judge Whitaker, she's not playing around again today. There we go. And let me make sure the sound is good as well. Y'all let me know how the sound is. Oh, also, if y'all could like the video on your way in, it's free.
The verdict forms.
There we go.
Okay, we need to make sure we have taken care of all of our last minute housekeeping on the indictment, the verdict forms, the charges. Ms. Persfield shared an email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those, I guess maybe the verdict forms are the easiest thing to look at first.
Good morning, Mo. Texas Tina, good morning.
And
good morning.
Y'all just let me know if those look okay.
Okay. You're looking at the email that says final doc?
Yes, final docs, charges, etc. from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which we definitely need to still address some things on, and then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first. And hopefully those are actually in final form.
This is minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
Here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that implies that they should find lots of acts. So I thought if we have a blank page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines, so,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines, but given that you've made it clear, you sort of made your mind up on this issue, I think that this is the most appropriate middle ground. The way it was before implied that there would be very few or any. And this is, as you said, it's a blank space.
Okay. All right. So any other items? All right.
And I don't know if it's the same thing Mr. Sharp's name got. On Mr. Stillwell's.
No, they're not dripping in blood today.
Yep.
For count 49 and count 52, just for consistency, I would put the not guilty first and then the guilty.
I agree. Don't know how that one happened. Ms. Persfield, can you switch those around? Thank you for that catch.
Your Honor, I'm going to object on count 2 and count 49.
Yes.
I don't think we should be putting the victims' names.
Why?
Well,
I mean, if you're going to object, you need to give me a reason.
because, I think it's clear what the 2 counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's charged with 2 murders. I don't think it's necessary to put the victims' names next to each count.
All right. Well, I appreciate that objection. I overrule it.
Thank you.
All right. Anything else on Mr. Stillwell's verdict form? All right. Hearing nothing, we will move on to Mr. Kendrick's verdict form. And it's possible that then, I don't know if we have a guilty, not guilty reversal on that one, but if
No,
we do, we'll
it's
fix it.
correct on that one.
Okay.
Or consistent. Let's use that
Consistent,
word,
okay.
consistent, Your Honor.
Yeah, Asia, we should have time to go over closing
All right,
statements from
anybody have
yesterday.
any issues then on that
Let's get
verdict
Northside.
form? I guess maybe you could, on the, I don't know why it's not showing up on mine. I don't have lines under this blank day of blank, but it looks like you do on yours, Ms. Pursfield, so as long as they're there. Okay, all right, so looks like at least the verdict forms are in their final form.
Wow, I'm impressed at them putting in work.
The redacted indictment, and as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established and the court has recognized an overt act doesn't have to be a crime, and therefore we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever, so.
That was the first part of my argument. The second second part is this. Under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same. You can't
Interesting.
demur to an overt act. And so it's while it might not be adequate as a freestanding charge, as an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy, because they're not separately convicted of this.
I don't agree. If you have law that is on point, show it to me, but if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I understand, Your Honor. As far as it not meaning to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that
he's not using the mics.
he
Sorry,
committed
man.
X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
So I was citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court. But I will tell you that it is well-established federal case law, for example, that if a defendant is charged, let's say count one is conspiracy, and there is an alleged overt act, that overt act is also alleged as count two, independently.
Right.
The defendant can be acquitted of count two because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of the conspiracy. Especially.
And then just a reminder about an overt act. I want to read it because if I try to explain it, I'm probably going to do too much. An overt act is an explicit action taken by someone that demonstrates their intention to commit a crime or further a conspiracy. So it's a conspiracy essentially to commit conspiracy. It is typically a visible outward step taken in the course of executing a criminal plan, and it does not necessarily have to be illegal by itself. The law is amazing.
Especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175, there's only Mr. Nichols.
Okay, all right. I still don't,
All right, again, if you
This is
find
the
some
law,
law that
y'all.
is on point, you let me know.
all right.
John, by that reasoning,
If you find some law, we'll deal with it further. Otherwise, let's move
I
on.
agree, I'm with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, and 190.
So on those, I would like to know, let's see.
Overt acts are crazy.
Good
Their
question.
intention to commit a conspiracy. Yeesh.
All right, 174 and which others?
189, oh, sorry, go ahead.
189 and 190.
Yeah, I think a good example of that would be Googling, I don't know, Googling trash bags and duct tape and ski masks. And picking up a shovel and the tarp at Home Depot.
I think
It's not illegal, but it
There's-
doesn't look great.
present the same situation.
Good morning, Rosie. I'm doing great. Hopefully you're doing well. That would be an overt act. God.
Yeah, I think you're correct.
Overt acts are crazy. Good Lord. I'm glad they're not talking. Dr. EJ, my goodness. Drop the 100 bomb. He says, thank you for doing an outstanding job covering this trial. I've enjoyed your commentary and all the hard work you've put into this case. I'm looking forward to the other cases and content you will make. Keep up the great work. Dr. EJ in here. Oh my goodness. You keep up the great work, Dr. EJ. You know I appreciate it, and thank you for everything that you do. And thank you for the support. You did not have to do that. Wow. Amazing, man. I'm so glad you found the community. I'm glad you're enjoying the content. I appreciate the support. I'm humbled, man. We're not stopping either. We've got so many other things we're going to be covering on this channel. So if y'all haven't yet, make sure you subscribe, hit the notification bell, all that. And shout out to Dr. EJ. My goodness. Thank you, sir. Can y'all spam Dr. EJ in the chat? Let me put him in the banner too. Goodness. No, even if Yak Gotti gets out right street, we are not covering Yak Gotti's rap career. I'm sorry. We might do some updates on him, but yeah, come on now. You know how I feel about Yak Gotti's music. Best drip out of all the defendants, though. So shout out to Yak Gotti. Dr. EJ, man, my goodness. Who's back there getting that fade? Somebody's back there getting a haircut again today. All right, thank the Lord for a delay because we ain't doing this.
March 17th, possession of a firearm allegation. It's also a substantive count 64, and it's saying that he did that on March 17th, and we know from the evidence that what everybody is talking about is the
Dr.
gun
EJ.
that was, I don't know if it was thrown out of the car, but the gun that was discarded during the chase.
Speaking of barbers, my barber went out of town before I could see him. I'm so disappointed. Trying to be fresh for Thanksgiving. He said, nah, man, I'm sorry. You're on your own. He is gone. Dr. EJ again with the 20 memberships.
And, you know,
gosh.
I think we were looking at
Thank you, Dr. EJ.
sort of the somewhat odd language of 1611-133.
If you got a membership from Dr. EJ, y'all make sure you say thank you. Goodness.
Ultimately, when it comes down to it,
Oh my gosh.
the state did not indict this correctly, and the state did not put it in the overt acts correctly, and they specifically alleged a specific crime in the overt acts. So we moved for a directed verdict on the on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that. But I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
Yeah, full nerd, I'm with you. I might have to do it myself. It for real sounds like somebody's back there getting their hair cut. Can they do that in the courtroom? And so they're asking for a directed verdict now. It's confusing by Max. Let me see if I can figure out what he's saying.
Yeah. I mean,
Shout out to Ashley.
I think those
Thank you.
overt acts need to be removed. 174, 175, 189, and 190.
Your Honor, may the state briefly address that issue?
Sure.
The state does believe that for some of the reasons that Mr. Floyd was just articulating about the case law for a substantive count of 133, as the court, as we have addressed, you can have the possession of a firearm by a convicted felon because it's a lesser included. Legally speaking, the argument for, an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by a convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do, because overt acts do not have to be crimes.
I understand they don't have to be crimes,
Yes,
but
Your
they've been
Honor.
alleged to be crimes with specific statute numbers. And yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in furtherance
Previously convicted of a felony involving use or possession of a firearm.
Yes, Your Honor. That in the state's mind, the lesser included argument on a substantive count is a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that that same legal principle of why a lesser included of possession of firearm by a convicted felon can be included on a substantive count is even stronger on an overt act.
So are you, so I'm clear,
Rico.
are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts?
RICO at its core is based on conspiracy and overt acts. So y'all have to, I know it's frustrating, but you have to think about RICO in general, which that's another conversation on the BS that RICO is. RICO is based on conspiracy, is based on overt acts. So in a sense, there may not be a lot of actual crimes committed in so much of this. That's just how lame RICO is, in my opinion.
As kind of a lesser included crime?
Yes, Your Honor. And if the state, if you, like, for example, if the state, from my understanding, were just to,
From my understanding, I believe.
redact, or essentially, yes, Your Honor.
All right.
And I'll let Mr. Floyd.
I mean, I think that there is evidence presented for that. It's, and I hope y'all understand what my thinking is on the, because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute, and that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon, you don't have to be possessing it while committing a crime, you just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to
Your Honor, can we just
supplement,
redo the indictment?
What my colleague, Mr. Adkins, was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point that this does different work as an overt act than it would as a separate substantive charge. Frankly, only the fact, just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. It just, he is in possession of a weapon.
I know,
The
y'all
rest of the
didn't
details.
allege it that way.
Well, that may be so, but it still does the work under it. I mean,
They're just
it
trying to
wouldn't-
milk as much of this.
They cannot return. I
they can.
find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element.
Correct.
So unless you've got case law, you're not going to convince me on that one. Okay. We have moved on to whether it should be redacted, modified to essentially assert a Section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the
Yes.
state may be able to find a case, but I haven't, I mean, and you may be aware of a case, Your Honor, and in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back
I do
and
not
fix.
have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made, or whatever, fix what they have done at this point in time by modifying
Over 100
the
that's true.
allegation
Yeah.
of this overt act. At this point, I just don't think you can do that. I think
I
the
don't
only
know.
option is to redact it, Your Honor, and it would be, I think it would be error to go ahead and change that.
I don't know. So
Because that's what we have been,
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175,
Oh, boy.
189,
This is gonna be a
and
long
190.
day.
They're absolutely not going to be included as a 133 offense y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that, but I don't know whether we can change it like that. So we'll come back to that.
Just so I'm clear, do you want specific law subject and apart from what was provided last week that would allow?
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act.
And in criminal law, 133 offense might involve something specific like giving false evidence in court, but depends on the jurisdiction. Oh, that was no help. I shouldn't have paused for that. Let me see if I can find something else.
So our next issue.
She said 131.
Let me jot myself a note down.
(131) assault, theft, or a specific
All right.
act.
The
depending
overt
on the legal
acts
framework.
that include Mr. Kendrick and others.
I see
that
you right straight.
I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up the, what count is that, Ms. Pursfield?
I know they're all exhausted after.
I'm sorry, the
statements
count.
yesterday.
We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. They're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Of course he is.
All right. Now, the somewhat more complicated issue is when we go back to the overt acts, because that same thing is essentially included as an overt act as well, and those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could think, well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that because they found that Mr. Kendrick.
Agreed. So here's a possibility.
All right.
So I'm going to throw this out here, and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick, and then maybe a 183A that says, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just be Arnold and Williams with the
Codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of can we then go and modify? I guess we can modify these overt acts. I don't know if we can modify.
Like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood. And if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely. But I don't think that is actually fair to the state when it could be that.
Yeah, they're not going to let that happen.
You know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
I'm not, while I probably should, I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative of some of those issues.
You say I probably should, but you shouldn't if you, I appreciate that you take your duty of candor seriously. I really do. Thank you. Yes, sir.
Your Honor, with regard to Act 183, if the jury unanimously finds that this overt act was in furtherance of the conspiracy, I believe with the instructions the court will be giving, when you have multiple parties, and could mean, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles, and if they do find this overt act is in furtherance, it will be following that law.
Here's the challenge with that, and just kind of think through this hypothetical with me. We have got overt act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then
there's talking with your hands, and then there's
the whole case gets reversed,
throwing
assuming
up gang signs.
That's what happens.
I don't know what Atkins got going on.
Understood,
And
John.
I doubt if that's going to come to fruition, but legally speaking, that's my worry with leaving it the way it is.
Understood, Your Honor. I'm thinking through it with the court right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have had no.
That's true.
Because there's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are allowed. There is no, Georgia doesn't have inconsistent verdicts in what they don't go.
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would qualify as that,
Griffin
but
say he's
it's
wild with that hand.
factually,
He stands up and
I don't know the answer.
Your Honor,
Your
I just know
Honor.
the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, I'd like you to bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between a substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they reject.
What's the overt act though? Can we-
Okay, but that's not
Sound
them,
like-
all right.
Drug charges?
If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who it's alleged to have done overt act 183. And I have directed, and it's only, Cody. And I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right, understood. It helps to frame the question.
Okay.
And we're going to come back and talk about it, so I don't want to.
All right.
I'd like to be better
Think it through
informed
before we
and
know what the case law
make
is.
better use of our time.
Okay.
Thank you.
Appreciate
Yeah,
it.
figure it out. I can't believe y'all are still doing
All
this.
right. The next thing is on the overt acts that allege possession of a firearm by a convicted felon. That aren't also substantive counts. We were adding
I might have to change this back. Come on now.
definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while
I believe.
he was convicted of, I don't know,
Where's the evidence?
dealing
morning
in
to the
some kind of
Honorable
drugs.
Attorney Cal Bell.
And we would need to have defined what is that underlying crime.
How did that happen? Uh-oh, y'all give me a second. Having some technical difficulties. Hold on.
In our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have committed,
Okay, should be good.
been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence, and that ought to be easy enough to check. And honestly, I think, Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was, what you said was 60G, 30Q, and 487VV. So can we just pull those or if you've got it on this, you had it as a slide, actually. If you want to just pull that up. too, and let's look.
And there are other convictions for Mr. Stillwell that were
Don't do
admitted
that,
as
Amy.
well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one. But looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the?
I mean, the actual
You want me to pull
piece
the
of evidence would be probably the easiest.
Shopliftings. So they were going around bragging about shoplifting in the furtherance of YSL. Yeah, y'all don't mess with us. I just got that 50-inch from Walmart. Stop playing. YSL out here. No, I'm not gonna do it. That's going too far. I'll wipe my nails, but I'm not throwing up a YSL. Too close to home. They were still in blank CDs. Yeah, we about to hit the Walmart. That new Thug Gunna album. What are we talking about? I don't know. Do y'all think shoplifting? That's a silly question. He stole them. I stole this milk so lives can enjoy the cookies. Oh my gosh. Yo. That's crazy. What's up, Gabby Gabs? Good to see you. I'm blessed. Better than I deserve. Y'all said shoplifting. What do y'all think they were shoplifting in the furtherance of YSL? Young Thug had them picking up TVs, blank CDs for his next album. Jeans. Oh man. Hey, good morning, Steppa. And let me pull up this indictment again. Oh, that's the wrong. I don't want it on this screen. And let me see if I can find these overt acts. Instead of asking the court, we can look at them ourselves. Let's do this. Able. You said they got green spray paint. Yeah, that's crazy. Here we go. Hold on. Let me do this. We're gonna zoom in. Do this. All right, so 131. They were talking about Young Thug appeared in a video released on social media titled "Ski," with the lyrics stating, "I mess with slats and we come to eat rats, and I came with some effing piranhas. I told an FM on me, call Nietzsche. It's a Glock he keep. Duke rolling 60s. He's locked in the seas and overacting furtherance of the conspiracy." What? Of course it is. And then 133. Diamante Kendrick, an associate of YSL, did post for a photo released on social media wearing a red bandana and a YSL pendant and overt act in furtherance of the conspiracy.
Right, and so what we have ultimately is that there is no evidence, none.
God.
Did y'all find the evidence?
Yes, Your Honor.
Can I look at it?
You were talking, that's why I'm sorry, I waited.
We were just dealing with other issues.
Three ketchup bottles or an overt act. That's crazy. Shoplifting large. Oh man. They shoplifted the
Your
large
Honor, unless I
cell
missed
bell.
it, I
That's
don't believe
hilarious.
the Arizona conviction came into evidence.
If 438 VV, now you had cited in your closing presentation 487 VV.
It was 438 BB, which is this.
Okay.
For.
All right. So it doesn't look like the Arizona conviction came in. So all right, so we're starting with overt act number 3. Y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
That is going to
These niggas lacking.
be, yes.
Hmm?
Well, no.
You are correct, Michelle.
It's neither of these.
I'm looking at the other one here.
Aren't there 3 for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me 2.
I handed you the 2 that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence? I just assumed that you had cited all of them in your closing, but that's okay. It's probably this one. No, this is a 10 SC. It can't be that one. It can't be that one either. All right, I think it's still somewhere in one of those bins, if it is in evidence.
Oh, it's right here. Oh, yeah.
And Amy asked this earlier. What do y'all think the verdict's gonna be? Not guilty on the murders. Yeah, I'm with y'all on that. There's no way. Well, I won't say there's no way. Anything's possible when it comes to the state. Y'all are saying not guilty across the board. Not guilty, not guilty, not guilty. Good morning, Floyd. Not guilty. After all that ghetto yelling Hilton did yesterday. Not guilty.
All right, Ms. Percifield, the
Was it
burglary
that bad?
one,
I didn't
there
see the
is
whole thing.
a conviction for, so we do need to define burglary in our overt acts.
Your Honor, for
Not guilty.
the 2013 Act 3, we put up evidence of that case. I don't,
Tw-
I'm
um,
trying to see
2013 Act.
Act 3.
Okay.
Sergeant E testified.
Okay. All right. As long as there's, okay. So there's some evidence. Okay.
Yes, Your Honor.
All right. Just a second. Sorry. All right. And we've already defined possession of marijuana and intent to distribute anyway. Yes.
I don't think it's necessary to define the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges
Not
guilty.
to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable.
Same here, Kel Bell. I agree. 1000%. I would never
All right, so
trust
then-
the jury ever.
55.
Because all it takes is one person to say the right thing, and then it goes all the way left. And juror 56 was talking all that talk. I don't think he's going to stand on business. He got in front of Judge Whitaker. He's like, oh, well, Judge, I guess it's okay. As long as we're done before the year. Stand on business, man. Nope, he folded. Y'all saying yeah. It was bad
Are there
Hilton yesterday?
other overt acts that have been proven by somebody else's conviction being admitted, such that we wouldn't have to define those either?
Yeah, D, I caught a few minutes. I didn't watch the whole thing. Not guilty on murder, guilty on the lesser charges. So they will be put on probation and they get to go home. I agree with Valencia. I think they're going to get a Thanksgiving size helping of probation. Oh my goodness, the Warren, what are you doing? Drop the 100 bomb. Sheesh. Thank you so much, DeWarren. Thank you for the support. What does he say? The way Max closed yesterday's, no way any of them should be found guilty. He really broke the state down. Stay blessed, brother. I appreciate you. You be blessed as well, DeWarren. And thank you for the 100 bomb. My God. What? I got it. Let me add DeWarren to the banner. Thank you, man. Y'all are showing so much love. I really appreciate it. Yeah, again, and Kel Bell said it. The Honorable Attorney Kel Bell said it. It's hard to know what the jury's
Y'all,
gonna do
Overt
unless you're in the
Act
room.
58, alleges possession of a
Thank you,
firearm
man.
by a convicted felon by Mr. Kendrick by possession of a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence? No. Not the Arizona conviction, but I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have for 38 BV.
Okay.
VV?
That October 1st, the conviction for that.
Yeah, you see that,
October 1st.
Shane? Everybody's showing love. Jury's supposed to be in about 30 minutes, so yes, that's correct, D. We'll see. We'll see if that happens. Right, Street, you just got approved for 300 million. If you don't stop and get out of here, let me hold a couple dollars. We giving you enough. Right, Street. I got something. Never mind.
All right.
Shout out to Rice Street was showing major love on the Song of the Night live last night too. Rice Street gifted 60 memberships last night. My goodness. Good morning, y'all. $60 memberships. Crazy.
All right, I'm going to give y'all back all of this evidence so you can put it back where it goes. And then have y'all come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence?
Oh no.
Your Honor, we are looking. Your Honor, we're looking at that now. And I think the court just addressed this, but just
that were a member of the media, George
Arizona
Whitaker would
conviction.
have popped
Yeah,
off.
we don't need that one. We just need that one's satisfied.
Thank you, Your
Thanks.
Honor.
Oh, Joseph Papp is on it. He said that was from someone in the DA's office sitting somewhere back here. It's probably Fannie Willis. Thank you, Mama D, for gifting the membership. Appreciate y'all. Thank you, Hardbody. Appreciate you, as always.
Yeah, 53.
Free Monk Talk. Oh, Monk Talk, man. Gotta be the worst part of this thing. Worst part of this trial is Monk Talk and Threat getting killed. Rest in peace, Threat. Man. And probably Rodalius Ryan too. That's a sad story. Yeah, what was that guy's name? Derek. What was his name? Derek something. I don't know why I can't remember his last name. Derek Wright. Ugh. Can we get some tomatoes in the chat?
All right, so
For Monk Tunk's lawyer, Derek Wright.
Sorry,
Goodness.
overt act 34 is Walter Murphy, possession of firearm.
Disgusting.
Do we have, is that established by a conviction? Or am I going to need to define robbery?
Garbage.
It's established by a conviction, so you would need to define robbery.
Okay, that may have been the only reason we were defining robbery. So we would not need to if there's a conviction in for him.
That's the worst plea
So
deal
we
I've
can
ever
take
seen
that
in
out of
my
our jury
life.
charge.
And I've seen a lot. Uh-oh, the camera's moving. There we go. Struggling today.
I'm glad you pointed that out, Mr. Abadi. That'll make it somewhat easier.
Yeah. Derek Wright. Boo. Derek Wright.
Oh,
Yeah. Has anybody heard if they're going to do anything about Monk Tunk?
all right, I'll have to look in a second.
Tomatoes that messes up the algorithm? Nah. We're doing fine. I don't think tomatoes messes up the algorithm. YouTube loves engagement.
Okay, it doesn't look like there are any other overt acts because I just did a global search in the indictment for the term convicted felon, and that looks like those were all of them that didn't otherwise have some definition anyway. Right.
Why having an issue today? I know. Jury's supposed to be in 15 minutes. Y'all think they're gonna make it? Fabin Forgotten says, I have no faith in the jury. I've seen too many jurors make a decision on emotion rather than evidence. Do you think, though, in closing, well, throughout this trial, and specifically in closing statements, do you think the state was able to play to their emotions and their benefit? I'm not seeing it. But again, we hate the state right now. I love the state of Georgia. We hate the state in this case. I thought Atkins did a decent job putting things together, explaining RICO, explaining the conspiracy. I didn't see Hilton yet, though. Joanne says Hilton's closing made me mad as a juror. They made Monk disappear. The state hid him in deep in the system. I live in Milwaukee. I've never heard of 30 years probation. I still, man, oh my gosh. Worst plea deal in history. It's got to be up there. Hilton got too ratchet during her closing. Wasn't a good look. Hilton's closing was ghetto, disrespectful. Oh man, we might have to get into that today. If we don't get into it today, we definitely will tomorrow. I don't think the jury appreciated the attitude Hilton had during her final closing. Ultimately,
Right, and so what we have ultimately is that there is no evidence, none.
another YouTuber said Hilton did pretty good. I didn't watch it either. Hilton was at her worst during closing, to say the least. Man. Shout out to Debbie in the building. Good afternoon, everyone, and good afternoon to the UK. Question: if they don't find them guilty of RICO, are they free to go? Sorry, I don't believe we have a RICO in the UK. No, because there are other lesser charges in this indictment. So if they're found guilty of those, they'll most likely only get probation because of the directed verdict that, or the partial directed verdict that Judge Whitaker is going to give. I can't imagine that it would be something that would require them to serve significant jail time. So in most of these cases, if they're found, oh, I'm sorry. You're saying if they're found guilty of RICO. Oh, if they're found guilty of RICO, they're going to jail. Yeah, if they're found guilty of RICO, they're not going home. And we're struggling today. Let me see if I skip ahead, because they're not saying anything anyway. Thank you, Mama D, for the 2 bomb. I appreciate you. Hilton was aggressive and savage, but when she made the remark on the red suit, she was petty. It was definitely ghetto. Rice Street says Trump is considering me for the head of the Department of Justice.
Stop the cap.
So I might be getting a pardon soon, man. If you don't. Yeah, Dennis says time served will factor in as well, but if they're found guilty of RICO, they going to jail. Straight to jail. I don't know why we're struggling today, y'all. And it looks like Judge Whitaker lets them take a break. So here's what I'm going to do. Let's go ahead and go back to yesterday while we wait for the jury to get in here. We can at least start to hear some of the rest of Max's closing statements because we missed the rest of that. Let me see if I can find it. And for some reason, my chat is not updating. Let me see. Here we go. Let me see what y'all are saying. Oh, shout out to the UK. We got everybody in the UK out here. Shout out to Colin. Good to see you in here. All right, so we're going to take this and we're going to swap these real quick. Let me see if I could find... I want to find where we left off with Max. 3. So we got Atkins. And then we had Max. Miss Love was over there squirming too.
And that was actually enough to put his plan in motion because he knew someone was going to...
Now we got to run back.
Quindarius Zachary? Is he on this indictment? No. Kenneth Copeland? Is he on this indictment? No. Are any of us going to really sit here and protect conspiracy? So, what do they focus on? They focus on, first of all, oddly, artistic expression. Jeffrey's lyrics. Like, we're just going to pretend there's not a thing called rap music. We're going to pretend there's not a thing called artistic license. We're going to pretend there's not a thing called YSL, the record label. And when Jeffrey says slat in a song or slime in a song, which is recognized worldwide and is popular and sells albums, we're going to pretend that there's no context to this, and we're just going to pretend that all these lyrics are somehow designed to further a RICO organization. That's absurd. We're going to pretend Shannon Stillwell's statements about bragging about beating a murder rap, which is good for his music career, is somehow furthering some criminal objectives.
You were right, Amy. Jeez, Amy wants me to say that she was
some
right.
Conspiracy. That's absurd.
You were right, Amy.
They list in their list of overt acts a bunch of social media posts. Social media posts of people with tattoos on their face. Nothing else. Just, oh, he took a picture with a tattoo on his face. Or wearing slime clothing or Make America Slime Again clothing. Clothing created, mind you, by Miles Farley, a person who was able to, again, turn negative into positive.
Okay,
and turn that movement that was going on. What does the state say were these overt acts? Well, they list a lot of petty drug selling. We heard from Trontavious Stevens. I don't know if you remember, but it was a long time ago, I know. But he talked about being pulled over. And I made sure to ask him. And he wasn't denying that he had a bag of weed on him. I said, hey, man, who went in on you, with you, on that bag of weed? I bought it. Okay, yeah, but when you sold it and made a profit, who are you going to share the money with? They look at me like I was crazy. Man, this is a $100 bag of weed. I ain't sharing money with anyone. I'm a drug dealer. I buy drugs and I sell drugs and I make a profit and I keep the profit. What evidence have we seen at all that any of this petty drug dealing had anything to do with furthering some criminal enterprise? It's isolated acts. They list gun possession. 2019, they say Shannon Stillwell is possession of a gun in furtherance of the criminal objectives of the conspiracy. Man, we have heard.
Man, I remember that.
Ever since Shannon Stillwell was falsely accused of killing Donovan Thomas in 2015, about people shooting at his head, people shooting at the car he's in. People are trying to kill him. And you think he's possessing a gun as some furtherance of some conspiracy? Does that make any sense? He's trying to survive.
Mm-hmm.
The murder of Jamari Holmes. Tragic event. Horrible. Complete waste of 3 lives. Jamari Holmes, Rodelius Ryan, and Mr. Blaylock. 3 teenagers, senselessly, all lose their lives to varying degrees. Jamari Holmes obviously loses his life in the most real sense. Absolute tragedy. No one's going to say otherwise. This listed as an overt act in furtherance of furtherance of the criminal objectives of the alleged conspiracy. It was like a 15-year-old doing something incredibly stupid. What objectives was that furthering? It wasn't. It's an isolated act committed by someone who screams out YSL and screams out SLAT. But that doesn't mean it's furthering any conspiracy. We hear about Jaden Myrick. First of all, who the heck is Jaden Myrick? I know they put him on this indictment like to try to say, oh yeah, he's a co-conspirator in this too. But they're the ones that put his name on this indictment. What have we heard about Jaden Myrick? We ever hear about Jaden Myrick ever meeting Shannon Stillwell? Do we have any indication that Jaden Myrick knows Shannon Stillwell? What about Jeffrey Williams? Any indication that Jaden Myrick knows Jeffrey Williams? Who the heck's Jaden Myrick? But some dope in the jail that's looking to make money by doing something incredibly stupid and attacking Rashawn Bennett. So he calls another dope, and they come up with their own little, hatch their own little plan, but it has nothing to do with some broad conspiracy that Shannon Stillwell willfully and knowingly joined. We heard about jail calls. They're all listed as overt acts. Cordarius Dorsey calling Antonio Sumlin. Hey, I want you to attack some guy named, Victor Meadows, I think his name was. I can't even remember the guy's name. Had nothing to do with this case. And
heard this, but
and Antonio Sumlin's like, what? And he's like, okay, man. And he hangs up the phone and doesn't do anything about it ever again. Is that furthering a conspiracy? And this was the coup de grace. Christian Eppinger has an armed robbery arrest warrant out for him. And the police jump out on him, unmarked police, and say, get down, boy! And he has a gun. And he gets into it, the officer, and shoots.
Yeah, we heard this yesterday.
And runs. Too. And then another officer shoots at him, and he shoots back, and he continues to run. Somehow the state is alleging that Christian Eppinger, no one else is there, no one's saying, hey, Christian Eppinger, do this for YSL. Christian Eppinger trying to avoid arrest, trying to stay free, completely isolated from anything else going on in this case. Somehow Christian Eppinger doing that making that idiotic decision to shoot an officer to avoid being arrested, somehow that is in furtherance of some conspiracy that Shannon Stillwell knowingly and willfully joined? Doesn't make any sense. In review of count 1, ladies and gentlemen, YSL is many things. It's not a gang, full-fledged or hybrid, and it's certainly not a RICO enterprise.
Certainly.
Shannon Stillwell, in associating himself with Jeffrey Williams and Trontavious Stevens and Quamarvius Nichols, his good friend, and Miles Farley and others, and Wooney Lee, he wasn't knowingly and willfully conspiring with anyone to participate in any enterprise aimed at a pattern of racketeering activity. He was in the mix. He was trying to make music. He was also, coincidentally, if we're being honest, he was selling drugs. He wasn't sharing them with anyone. He wasn't sharing the profits. He was selling drugs and trying to make music. And he was around the right people to be trying to do that with, because those connections were going to, in his mind, further his music career, which is what he wanted. And no overt acts were ever committed in furtherance of any conspiracy that Shannon Stillwell knowingly and willfully joined. The state has to prove every element of that charge beyond a reasonable doubt. They have failed. There is reasonable doubt. It's not true. And your verdict on count 1 must be not guilty.
Okay, here's where we left off.
Let's talk about count 2.
Count 2.
Just, Kokomo, if you would, pull up page 21.
Here we go. Now we're getting into it.
Actually, you don't need to do it. Count 2 is the charge from January 10, 2015, the murder of Donovan Thomas. Okay? But before we start talking about the evidence in the case, and we will, let's talk about music. Okay? We know that Shannon was working on music. I think we've made that clear. Through his phone, through the fact that he's always at the studio, through the fact that he has songs on his phone, multiple songs, some we've heard, some we haven't heard. Clearly, that's what he's doing in life. And we've also heard about drill music. We heard from Investigator Viverito. We heard from Antonio Sumlin. We heard from other people. We heard about the common themes of drill music, the things that make you marketable in that space. Okay? Violence, confrontation, having bodies, homicide, guns, more guns, bigger guns, being the toughest, being the baddest, not being scared, being a danger. Okay? And I'm not asking any of you to like that. I'm not suggesting I like that. Detective Underwood, she clearly didn't like it, and I'm not saying she's wrong. But it is what it is. That type of music exists. That type of music is popular. And that's the type of music that Shannon Stillwell was doing. We heard about the common terms in this drill music. Ops, glizzy, blicky, red lights. And we heard 5 of Shannon's songs. We heard Slap Talk, Lizard Walk, Red Light, featuring B-Slime and Vito.
Shout out to everybody who's double dipping.
SHIT with Dolly, Jeffrey's sister, and ran this money with Slime Life Shorty, a signed
Killing me today.
Artist who had already made it, at least to a certain degree. And in those songs, I agree. We hear about all sorts of violence. We hear about red lights. We hear about glizzies, walk them down, homicides, FNs. We hear it all. And out of context, it doesn't paint Shannon Stillwell in the best light. And I don't think I've ever claimed that Shannon Stillwell is an angel either.
Thank you, PJ.
But it is art. And when he references beating a homicide, when he references beating a murder rap, when he keeps bringing up Donovan Thomas, it's not a confession. That's how he's known. That's what he's known for. That's his selling point in this type of music that celebrates it. Much to some of our chagrin. It just is what it is. We saw a post
I don't know why
that Shannon Stillwell made
I apologize, y'all.
on January 27, 2022. Page 24, Mr. Kokomo. And this is the untranslated version, but I'm not hiding from it. The translated version says peanut stone grave. But what does it say? I fell off 100 times. 100 times I bounced back. Life size. Hashtag life size lizard. Lizard, what he's rapping under. Lizard walk. Okay? And it says Manny Tumpa de Piedro. What's he talking about here? Fell off 100 times. Why does he keep referencing Donovan Thomas? Years later, he's already been arrested for this charge. Wouldn't he be quiet about it?
Right straight, leave me alone.
He would if he did it. But why does he keep bringing up Donovan Thomas? Well, I have two things for you to consider. First, maybe, just maybe, on that particular day in June of 2022, Shannon Stillwell had enough. For 7 years, the police put a target on his back, and people had been shooting at him. He was shot at the green store. They shot at his head. He was so bold to go to JJ's Chicken and Fish to get himself some food with the mother of his child and another female who was driving. He was so bold to do that, that when they left that parking lot,
double check and see.
3 men in a car sped up behind him and shot at that car, riddling the back of that car with bullets, shooting poor Tierra Jones in the face, instantly killing the driver, Miss Jones, causing the car to careen and turn.
You flipped the car. And they are not back yet, y'all.
Turn over and over and over.
So we're good.
Severely injuring Mr. Stillwell, scarring his head to this day, putting him in the hospital for months, putting the mother of his child in the hospital for a month. And then, when the police come to talk to Mr. Stillwell, remember what he does? He feels bad about the situation. He feels awful. He asks the officer, can I write a letter of remorse to Tierra Jones's family? And he does. And then the officer says, well, can you talk to me about the case? And know what he does? He talks to the officers about the case. And he gives names. He gives names of the people that he feels were in that car, that red car that sped up behind him, tried to kill him, and killed Tierra Jones. Mm-hmm. He gave up those names. And what was his reward? Page 26, Mr. Kokomo. I think it was Investigator Griffin, I think is the investigator that was investigating that case. And what did he tell you? The discovery got out and it was posted online. And the fact that Shannon Stillwell had dared talk to the police to try to help solve the senseless murder of an innocent woman was broadcast on Instagram and social media. And people were chastising Shannon Stillwell and coming at him on social media and in real life over the fact that he was made such a ridiculous decision as to try to bring justice to Tierra Jones's family. That was his reward for that. So yeah, people shooting at his head, narrowly missing at the green store. People shooting at him in a car, killing someone in the car and putting him in the hospital. Mm-hmm. People chastising him online for being so bold to tell the police what happened, who killed Tierra Jones, poor Tierra Jones. So yeah, maybe in January 2022, just maybe, possibly, he had enough. He was sick of the nonsense. If you want to say it, then I'll be it. You keep putting me down 100 times, you're making me fall, and I keep getting back up. And what's it all, ultimately, what's the origin story of it all? The death of Donovan Thomas. That's how it started. It doesn't mean he did it. That's how it started. That's why he has that target on his back. There's another possibility as well. Mr. Stillwell is just a kid who was raised by his grandmother in Thomasville. Nothing more, nothing less. But all of a sudden, he was known as a tough guy behind this. Wasn't true, but that was the public perception. That was the persona that was thrust on him. And maybe, while he was sick of it, sick of being shot at, sick of being chastised, sick of being threatened, maybe also a calculation was made, you know what? If they're going to keep shooting at me, I might as well lean into this a little bit. That does have traction in the streets. That does have traction in the music industry. Maybe that's why he's hashtagging his rap name in the post. The bottom line is, yes, I acknowledge he's referencing Donovan Thomas in songs. He's not giving any inside information in these songs that wasn't publicly known. Remember, he had been arrested. He'd been at prelims. He knows what the case is about. He's heard testimony about the case by this time, by the time he's making his songs. So he's not sharing any information that only the killer would know. Of course he's not, because he's not the killer. But maybe he is leaning into the bad boy image a little bit. But here's the thing. You might like my explanation or not. But could you put on 27, please? But let's just think. If songs were confessions, what would that really mean? Could you put on 28? Remember that song, Homicide, by Lil Woody, Kenneth Copeland? Who played the role of the assassin? Threat, Trevante Turner. You watched the video. I don't think we need to watch it again. Who gets killed? Someone who looks like Donovan Thomas. Who put money on his head? Kenneth Copeland. If songs are confessions, then Kenneth Copeland is confessed. He hasn't been charged. He's not sitting here on this indictment.
Wow.
So maybe songs are just songs. And posts are just posts.
Wow. Hold on a second, Max. Dang. You didn't have to cook like that. And we talked about this when we were going through all these plea deals. The state was dropping murder charges like hotcakes. You're like, don't worry about the murder. Nah, it's fine. Don't worry. That murder, it didn't happen. It's clear to see the agenda that they've had throughout this entire trial. Masterful job done by Max in this part. I mean, he killed the entire thing, but this is crazy. And then bringing up Woody at the end, reminding the jury that they gave him immunity and he's most likely the one who committed the crime. Wow. Amazing job by Max.
So let's talk about Donovan Thomas and some of the evidence in this case. Eyewitnesses. Who did we hear from? We heard from Reginald Hendricks. He was a gentleman that was shot. He was standing near Donovan Thomas. He didn't identify anyone. We heard from two witnesses, two people that were in the barbershop, working in the barbershop. They heard shots. They ducked. They described what happened afterwards. No one identified anyone out of those two witnesses. We heard from a man named Sammy Davis, an older gentleman who lived across the street, who knew Donovan Thomas. They called him Car Wash. He washed Donovan Thomas's car. He didn't see anyone in the car. That was his testimony. And then we didn't hear from, but we heard about someone named Spencer Wright. Well, actually, we heard about someone named Nicholas Robinson. What did we hear about Nicholas Robinson in investigation?
Oh, that is not what I wanted to do. Hold on a second. Oh, I lost my place. Dang. I was going to pause it, but we'll get back to where we were. Looks like the jury's in, y'all. So we're going to rewind it a second. Judge Whitaker is about to bring them in and tell them what they're supposed to do. Here we go. We'll get to the rest of the max here in a second.
I was not able to find
See where I left off.
Okay.
Can't believe I lost my place. Hold on a second. Let's see. We were at the... $523.02. Got it.
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F2nd 880. It's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive did require acquittal on a RICO conspiracy. And the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction. But that being said, we are looking at the changes that were just forwarded to us, and think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues we've been talking about.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway. So, all right. Anything else then? Otherwise, I'm going to have the jury out and go ahead and charge them. All right, let's get the jury out.
Here we go. VV? John said Hilton's closing arguments reminded him of Fanny's speech at the church. That speech was brutal. Absolutely brutal. And there should have been a bar complaint for that. Mark H says, I say the jury will be delayed by bookkeeping on 65 counts, so over 8 hours. but they will tell us it was never in question. Do any of y'all think the jurors are going to speak out after this trial? I wouldn't. I go home, say, thank God. Misogynist hating on you. Oh, man. It's not me, y'all. They muted the court. Law and Crime muted the sound. Let me see if I can find it somewhere else. It's not me.
And every essential element of the crime charged beyond a reasonable doubt.
Let's see if I can find it on.
Of a felony involving the use or possession of a firearm.
All right, so Law and Crime is fired.
Mr. Stillwell has been indicted for counts 1, conspiracy to violate the racketeer influence.
Also, everybody had it muted. I take it back, Law and Crime. It wasn't y'all.
Or unsatisfied, then that
So we missed the whole first
violation of the Georgia Control.
Gosh. All right, here we go.
Violation of the Georgia Controlled Substances Act. 61, possession of a firearm during the commission of a felony. And 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is a doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason.
Seems
it does
pretty
not mean a
straightforward to me.
vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant.
Very well said by Judge Whitaker. What do y'all think? Do y'all think that that doubt exists in at least one, just one of the jurors' minds? And do you think they're going to be able to stand on that and not get pressured into going one way or the other? What do y'all think? And Judge Whitaker gave a great explanation.
If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses.
Y'all are saying there is some doubt, definitely doubt.
The exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, in any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose.
These are excellent jury instructions.
Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime.
Thank you, Nietzsche.
A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy.
Nope.
For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish a or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator.
Wait, hold on.
Aware
Let me
of
run
all
that back. Say that again.
Knew all approved that each conspirator agreed with every other conspirator, knew all approved.
Hold on, I gotta run this back, y'all. Give me 1 second.
Conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy.
Here we go.
Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish a or to pursue a common criminal objective.
Ugh, I do not like that definition. Conspiracy is conspiracy, though. And someone mentioned a couple times in this chat, conspiracy is going to be a tough one to beat. Man, that definition is
The existence
rough.
of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state
So basically, just being in YSL isn't the conspiracy. But if they were in YSL and they had a common goal to commit these criminal acts, then that's the conspiracy.
Association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act.
Interesting.
The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence.
The issue is they haven't proved the enterprise. Oh, I should not pause Judge Whitaker there. Hey, my bad, Judge Whitaker. Eesh.
Obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity.
Criminal gang activity is going to be a tough one. She took a sip of her coke. Ew.
For
Judge
malice
Whitaker.
murder, the state must
Diet
prove that a
Coke?
defendant caused the death of another person unlawfully and with malice aforethought.
Where's my water?
The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart.
Yeah, not Diet
The
Coke.
state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have, to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols, or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person.
Did they prove that?
An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, I need to add that word, probationer. The state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun.
She's drinking Coke right now.
The state must prove that the
Nasty.
alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell.
When did the state prove that they were in possession of those drugs? Maybe I missed
Sale of
it.
marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana. And sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen.
Ugh. Here we go.
And was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again,
I know why I did this. I got y'all. Hold on. We were doing so good too.
again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12
So hopefully it'll be 56.
of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom.
Dennis, that
the
was
end of
56.
my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, 56. And 508 to hang back with me.
Oh, wow. Why
and the rest of you can return to the jury room to elect your foreperson.
All right. Judge Whitaker. Brilliant.
Perfect.
Excellent jury instructions. Clear, concise. And she really, I don't want to say they were in favor of the defendants, but I'll more so say they were in favor of the law and the legal process, because the state forgets this, but these men, both of them right there, Shannon Stillwell, Diamante Kendrick, are innocent until proven guilty. So she asked the jury, have they been proven guilty?
Right. And so what we have ultimately is that there is no evidence, none.
Very, very, very well done, well communicated, well written jury instructions. Judge Whitaker nailed that, in my opinion. State needs to take notes. Yeah, she said 387 got to hang back. 56. He already let her know what he was going to do. And someone was asking about the jury. Oh, Asia said, what happens if the foreperson, F-O-R-E, person says guilty, but everyone else says not guilty? Can they take it back? No, if that happens, then they just have a hung jury.
All right. Y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take, and so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at
Although
any
they
kind of
will.
social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially,
will.
you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
All right, shout out to the jury. Man. What
Are
do
there
y'all think
objections
is
to
gonna
the
happen?
charge?
Just a few things that we let Your Honor.
Okay.
On page 2, Your Honor.
On page 2.
Thank you, Angela. I appreciate you.
Okay.
When reading.
Sean said they already know.
Participation in criminal street
Yeah,
gang
they do.
activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on a second. Let me get there. Page. Where are you talking about?
So count 50, where it has participating in criminal street
Yes.
gang, you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you, last paragraph, any out-of-court statement,
Hang on. Yes.
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement or made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
Yes, so just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back,
Sure.
that's all, Your Honor. I'm just going back.
Made by one of the defendants, made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to
here we go.
renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of a firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know, Your Honor, stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Unanimity.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Unanimity.
All right. Then we will, y'all have agreed as to what evidence goes out?
Unanimity. Unanimity.
Yes, Your Honor, there is.
Unanimity.
We're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're putting on a piece of paper.
Okay.
And we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, you know, I'd like to watch the FedEx tape again.
Okay, my understanding, and I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled?
Jeez.
Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, and I believe the defense counsel has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We've
letters?
organized them.
I don't know what you mean by that.
So every act that we presented, so for example, VV was the Shamel Drinks homicide, so that they could know when they pick up a letter, what that was in reference to.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence, and quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted through Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise
That's true,
agreed
Amy.
on what evidence goes out with them and what evidence doesn't?
But I truly think there's one person that's going to be like, I just need a little time
Case
to
law this
decide.
morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was
I
one
agree, Sean.
bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay.
Mr. Sharp,
All right, does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence.
Okay.
That demonstrative evidence does go back to the jury, and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
The state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Okay.
I was just thinking that,
And then how about the
PJ.
CAD reports?
Nobody's looking at
what's
CAD
the
reports.
objection to the CAD reports?
We don't remember what those numbers mean.
And does the
Who responded to
state
what?
have a position on that?
They don't care.
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule.
Bobby
and we
T
are
knows what's up.
Looking, I thought we had the case on point, but we are looking for that case as well.
Amy, you know she's got to get the last word. Hilton's not sitting down. Dennis said they need 3 more days to get that $75. Oh my God. Oh man. Gotta pay that light bill. There were so many numbers and codes in those CAD reports showing what it means, which officer responded, how many officers responded. I don't want to see the CAD reports. It doesn't matter. Imagine we're sitting here and Judge Whitaker's like, oh, it looks like the jury has a verdict. Okay. That would be crazy. Let me see. Give me 1 second. I wonder how much long they have here. I'll be right back, y'all.
Yes.
Okay.
I have a case, Your Honor. It's a March 2021 case. I'm going to spell it P-A-T-T-A-R-O-Z-Z-I, State 385 Georgia Appeal 675. It stands for basically what the continuing witness rule applies to, and a CAD report would not be something that is listed as something that wouldn't go back because it would be a continuing witness because it's an original evidentiary document and it's non-testimonial in its nature.
Does it cover CAD reports at all, or is it just kind of here's what continuing witness means?
It's kind of just here's what continuing witness means. I couldn't find a case specific or on point as it relates just to
It's hard to believe, honestly.
which leads me to the conclusion they go back.
Yeah. So does the defense have any case law on CAD reports?
Does the defense
So I'm looking
care
at
about
a
CAD
case,
reports?
Muse,
Nope.
from the Supreme Court from last
sure
year,
don't, Your Honor.
316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos, and it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted?
That's a great point, John. Told Miss Love she had to step down. I know y'all don't have Amy crying at the table.
What does CAD stand for? Computer aided.
Don't have Amy crying at the table during Thanksgiving. Come on now. Because y'all got this one wrong. Ruin my Thanksgiving. Let me see what y'all are saying on this poll.
Adam, I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls, in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and that was why I wanted to share that.
Just Whitaker said.
And this is coming from.
These niggas lacking.
I want to.
Good Lord.
I believe it's the same case that Mr. Abadi cited, the PATTA. Yeah. But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case. It's pretty new. It's Davis v. State, which is 371, Georgia Appeals 469. It's a 2024 case.
I mean, in the Paterazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony.
The CADs were interesting for me.
And it
'cause I
is original documentary
nerd out about that
evidence.
stuff, but it's a lot to go through. Appreciate you, Anton.
And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
It's never too late for a not guilty verdict. I cannot type today.
It's completely accurate, as we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections.
Right.
And some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes.
Shout out to D Moyo. Verdict by 2 p.m. Not guilty. Wow. Okay. That's funny. Oh yeah. Nah, you're not. We're all learning here at JBC. JBC says, what are they still fighting for if they instructed the jury? They're still fighting over the jury form. So Judge Whitaker gave her instructions. Those really aren't going to change based on how they update the form. So they're trying to finalize what all they're going to send back to the jury for them to make their verdict or to make their decision. So that's all that's going on right now. So they haven't given the form back to the jury yet. So they're not technically deliberating, which, I mean, they probably are at this point, but you know. Yeah, that's a great question. Assad with the 2-bomb. Where's Mr. Sprinkle to make sense of all this? Actually, I know. Hey, Fitz said the jury is probably asking the bailiff for the form so they can mark it. Hey, man, I can still catch that flight tonight and be at grandma's tomorrow morning. Hey, bailiff, what we doing, man? Let us deliberate. Amy with the cake. Oh my gosh. Thank you, Amy. I don't know. I don't think we're going to hear anything else groundbreaking. What do y'all think? Sound is crazy. As a producer and an engineer, my ears are just boxing the air right now from this buzzing. All right, y'all. I can't do it. They're going to send back the jury form. We'll hear from the jury. What are y'all saying? Let me see. So we're going to end the poll and I'm going to officially see what y'all think about what is going to happen once the jury gets this form. So I asked, when will the jury return their verdict? The answers were, with 37% of the vote, by the end of the day. 33% of you agree with me and say tomorrow. You agree with me and Will. Will served on 2 jurors as a 4-person. And that's what he's thinking. 18% of you say next week. And 10% of you say after an hour of receiving their forms. Wow. Y'all 10%, y'all are ambitious. I do not have that much faith in this jury. And Kel Bell mentioned it and says it again. I hate to be negative, but I think the jury will take at least a week. Oh, the honorable attorney Kel Bell. Shot to the heart. But hey, as long as they get it right. What that means, it's up to them. Thank y'all again for the love and support. Thank you guys for watching. Continue to support, like the video. Shout out to the major sponsors of today's show, Dr. EJ and DeWarren. Oh my gosh. It'll be interesting to see what happens. We are going to be live tomorrow, and on Thanksgiving Day, I will have some pre-recorded content for y'all. So make sure you stay locked in, subscribe, hit the notification bell so you don't miss any time we go live or drop a new video. We'll be back tomorrow at 9:30. I don't know if they're going to have court tomorrow. I would be surprised, but we still have those closing arguments, our closing statements we have to get to from yesterday afternoon. And I think there's still some interesting stuff there that we may have missed and haven't covered on this channel yet. Either way, y'all have a great rest of your afternoon. And if I don't see you, hope you have a happy Thanksgiving. I appreciate y'all. Have a great rest of your day as well. And you know what to do. Keep growing, keep pushing, keep it classy. We go. Peace.